Oh, okay. Mr. Prater?
Good morning, Chief Justice Marshall, Associate Justices. My name is Donald Frylew. I'm here for Defendant Lawrence Zinser. There are two general thrusts to Mr. Zinser's argument this morning. Number one is that what happened in this case shouldn't have happened anyway, even under the current waiver rule. And number two, rather than deal with these matters on a case-by-case basis, the better, more efficient approach is to follow the lead of a unanimous United States Supreme Court in Massaro versus United States and hold that an ineffective assistance of counsel claim may be raised in the first instance in collateral proceedings, irrespective of whether it could have been raised on direct appeal.
Now, I take it that, as you know, and as the Commonwealth points out, Justice Kennedy's opinion specifically relies on the fact that you've got to file a timely motion, correct? In other words, there's a very limited period of time in the United States, in the federal courts, within which you may file this kind of motion, correct?
There is a time limit. That's correct, Your Honor.
And we don't have we don't have that time limit.
That's also correct. But Justice Kennedy's opinion does not mention the time limit, and
Yes, it does.
This argument, I mean, as a reason for adopting this rule.
No, but you can just assume that that's, I mean, the word is there, and that's, presumably what he was relying on.
That's correct, Your Honor, but it's not raised as part of the argument, and this argument has been going on since long before the enactment of the EDPA. I mean, this predates the EDPA by 15 years at least.
Maybe I'm confused, but do we have a waiver rule here in Massachusetts? I'm reading from Commonwealth versus Randolph. All claims, waived or not, must be considered. The difference lies in the standard of review that we apply when we consider the merits of an unpreserved claim, unquote. An unpreserved claim is considered under the, quote, default standard of review of substantial risk of a miscarriage of justice. So do we have this waiver rule here?
Well, we have a rule of waiver that applies to claims that could have been raised on direct appeal, that really could have been raised on direct appeal, and were not.
Well, we deal with half of the Supreme Court. I mean, you're saying that you get a different standard of review, right? You get the substantial risk of a miscarriage of justice standard of review.
Only if it actually wasn't preserved. If it wasn't raised on direct appeal.
I understand. And then do we not have case law that says, which is in essence deals with the first half of what the Supreme Court is dealing with, namely, if you have different counsel, don't we have case law that says if you've got the same counsel and you direct appeal,
yes, Your Honor,
it's not waived?
Yeah, that's correct.
Okay,
there is that case law out there.
I mean, they're very good policy reasons. I mean, I think that the Supreme Court and all the other courts of appeal that were in the majority, they're very good policy reasons why, when you've got an ineffective assistance of counsel claim, you may well want it to go through a motion for a new trial, because that then permits you to, put in evidence which is different from what one is putting in evidence if you're trying to find that somebody's guilty, correct? I mean, it's helpful, and we often say, was a motion for a new trial, where was trial counsel, there's no affidavit. I mean, there are lots of reasons why you want to have that record that is separately developed.
Absolutely.
And frequently, when there is such a motion filed, trial judges or we almost uniformly say, if it's an ineffective assistance of counsel claim, send it back and have a hearing on that, and it may remain as part of the direct appeal.
Well, what does this Massaro case do for you that our law doesn't already do?
Well, what it does is it prevents this kind of thing from happening again. This is a situation, we shouldn't be here. This case could not possibly have been resolved.
All right, so the judge erred. It happens. That's why we have appellate courts. But since we've said that that we consider the merits of an unpreserved claim and we just apply the different standard, so this judge shouldn't have said that as a matter of, I think he said as a matter of discretion, he deemed it to have been waived.
That's my
Without
question.
any
What does
reference-
this- what does
Why
this
do you
case
need
do
this
for you?
rule? Yeah.
Yeah, it doesn't do anything for you. We've got hundreds of ineffective assistance claims that are being brought in collaterally in motions for new trial, and we treat them under the standard that was just mentioned. So what do you gain by this case?
Well, I think every practitioner in the Commonwealth gains in the future, and I believe the appellate courts gain in the future as well, because they're not going to be having all these underdeveloped, half-baked, ineffective assistance claims darkening their doors. They can be brought in the first instance in the trial courts. And you know, had we
In
had...
essence, what you're saying is, what we do almost, I mean, by routine practice in the Supreme Court, where we get a direct appeal of a conviction of murder one, and a motion for a new trial is filed, we stay the direct appeal and we send it back down, correct?
That's typically done.
That's almost invariably done on a murder one conviction. It's not typically done in the appeals court, and you're saying not so much that we should, as I understand, not so much that we should adopt the Massaro rule, but where you have an ineffective assistance of counsel claim, send it, bring it in the trial court, send it there in the first instance, correct?
Yes, and actually that would be an adequate substitute for adopting the Massaro rule. Is simply a rule that, you know, these claims will always be kicked back to the Superior Court, unless they're manifestly...
Or you're saying essentially create a, you know, the functional equivalent of the U.S. Code and say bring them in the first, if it's an ineffective assistance of counsel claim, bring them in the first instance. And then it's an administration, because there are two ways that one can view this. The first is to say our practice has been to look to see if there was any error in the first instance. And you're saying that's not going to, you know, you send it up on appeal. If the appeals court says there was no error, not a problem. We put it under the nomenclature of ineffective assistance of counsel because usually that claim has been waived. Not the claim that it was ineffective assistance of counsel, but the claim that there was error.
Oh, the claim, yes, I understand.
And our way of dealing with that is to say, let's bring it up here and see if there was an error, and then we have in essence said, look, if the lawyer making the error in the trial court is the lawyer on appeal, that same lawyer, the chances are that that lawyer will understand that there's an error is de minimis.
Well, this is not a claim of trial error evident on the trial record. This is a claim of an omission.
I understand.
Failure to
That's a
investigate.
subset. So our way of dealing with it is to say, we're going to give a pass to those people. I'm talking about legal errors. We're going to give a pass to those people who have the same lawyer at trial and on appeal if it's a legal error. And then the ones that have to do with the failure to investigate and so on and so forth. I can't think of one off the top of my head, maybe this is one, where you don't send it back for some kind of record.
Again, that's, you know, I'd like to be able to count on that, you know, with a specific ruling. I can't count on it.
We can give you that ruling in this case. We don't have to change our law to get your result, which is that the court needs to deem this not as being waived, or if even as being waived, it still must rule on whether there's been a substantial risk of a miscarriage of justice.
Well, that's correct, Your Honor.
And that may mean having a hearing, and it may mean giving you funds for expert investigation, etc.
That's what I said to you. What do you need this Massaro case for? Massaro has got nothing to do with this. Our law is settled on this whole thing.
What you do is you have trial counsel saying you have got an ineffective assistance of counsel claim that in fact gives rise to a factual question. So please send this back. No, you can file a separate motion. Please send it back because this is going to require an evidentiary hearing. It's going to require, you know, which is in essence what a Rule 30 motion is.
Well, but I guess the point I'm trying to make, and to connect it to this case, is that this is such a clear-cut case where the trial record was...
The trial record doesn't address this issue, correct?
Excuse me?
The trial record doesn't address this issue.
It doesn't touch it. It doesn't go...
Why don't you have an affidavit from trial counsel here as to what his purpose was in not investigating this defense?
But first of all...
If you're going to go into that part of this.
Again, you know, we haven't had an eventuary hearing. We haven't had an
No,
opportunity...
forget your evidentiary hearing. Why don't you...
I spoke to trial counsel myself. And he told me what he did. Now, I could have gotten an affidavit from him. I submitted my own affidavit explaining what he did and didn't do with respect to this issue. Number two, I intend to make the argument that it's apparent from the docket that trial counsel did not seek funds to engage an expert, and that an expert for the defense is a sine qua non of an adequate investigation into a serious question of the defendant's mental health at the time of the offenses, and that you cannot conduct an adequate investigation without the assistance of a paid expert. So whether or not, I don't think an affidavit from trial counsel would have been at all helpful at this point. I mean, I think it's readily apparent from the submissions I made that not enough was done at this point.
Could the original appellate counsel in this case have filed a motion for a new trial?
He did.
Yes, I could have.
Yeah.
Yes, I was original appellate counsel.
So how does that change the standard of review?
You filed a Rule 30 motion, right?
Not while the appeal was pending.
Oh, okay.
No, I filed it afterwards. I made a conscious decision not to raise this point on direct appeal because I didn't have an adequate record. I didn't have anything. How am I going to raise this issue?
Well, and stay does that make a difference in this case to have filed a motion and then sought a stay, so that they could both so that the motion for new trial could come up with the direct appeal, the way it usually does in first-degree murder cases?
That's what I was saying.
Yeah, it certainly could have been done that way.
But does it change the standard of review?
It shouldn't change the standard of review.
Yes.
It does. Our case law is that you see there's a real difference between legal error and what you're arguing, the failure to investigate. They're really two different animals. I mean, our case law says that you get the full benefit.
Except that there is something on the record, in the trial record, that indicates that at least there was an awareness by the prosecutor and defense counsel, trial counsel, that this at least was an issue that was out there.
Correct. That's what tipped me off.
Yeah.
That there was something to investigate with the assistance of an expert.
If we adopt some sort of a rule, the way we have it for capital cases, that the direct appeal is stayed and the motion for new trial, everything comes back up together, is that going to work, though, for non-capital cases? Because it takes longer, I assume, to get your affidavits and everything you need for your motion for new trial and get a hearing and prepare all that. In an average case, we say you get 3 to 5 is what I'm saying, and by the time you get your motion for new trial done and you get your appeal, the time will have been served.
Well, it certainly makes sense as a rule of practice for defense attorneys to do it that way.
What you're doing is saying don't hold up the appeal. In fact, there's been considerable, concern about the way that motions for a new trial and automatic stays delay the appeal. Don't hold up the appeal. I mean, in essence, what I take the Committee for Public Counsel Service to be saying and the Massachusetts Association of Criminal Defense Lawyers is, don't catch us in between. On the one hand, we're pressing legal issues, jury instruction, sufficiency of the evidence, and so on and so forth. But there's this other body of ineffective assistance of which there is no record in the trial court, because that's not what the trial is trying to do. And please let us just bring that separately without saying we've waived this, because that just complicates it.
Yeah, exactly. Give us an opportunity to accomplish our goals on direct appeal, and if that doesn't work,
but you in effect did waive it. You were aware of this when you brought the direct appeal, and you didn't file a motion for new trial at that point. And what they're talking about is when ineffective assistance comes up after they've had the appeal and they now see that there's perhaps an ineffective assistance claim. But you knew about it.
But you're
I
saying
didn't waive it. I deferred it because I had inadequate
nothing.
information on which to.
Well, you could have filed your motion and asked for a stay. I mean, all this gets you is a different standard of review, as far as I can see. Between, if you had not deferred it, you would have gotten prejudicial error. By deferring it, you're now into a substantial risk standard.
And that's the Hobson's choice that trial counsel faces on this issue. I mean, appellate counsel, what do? Do you
That's no Hobson's choice. You just filed a motion when you know about it. You're supposed to file a motion as soon as you're aware of what the grounds are.
Well, it needs to be investigated. This is something, the whole point is that there needs to be a thorough, adequate investigation before you can bring this kind of a motion. There's so much to be learned about the defendant's mental condition. You got to have them examined. There are voluminous medical records that have to be gone through. This is not something that can just be cobbled together in a week. And it's a big undertaking, and this has been a very large undertaking for me and for my unpaid expert.
Thank you, Mr. Flanagan.
Thank you.
Ms. Lilios?
Good morning, Your Honors. My name is Loretta Lilios. I'm an Assistant District Attorney with Middlesex, and there is no need to abandon the waiver principle and adopt Massaro because we already have a mechanism that addresses all of the defendant's legitimate
Well, that's what I
concerns.
said. What does Mazzaro add to our jurisprudence? Nothing.
It not only adds nothing, but we have an additional mechanism here that would permit all of the defendant's concerns to be addressed in a way that also conserves judicial resources and respects principles of finality.
I have to tell you, Masala makes a lot of sense to me if you include the timeliness provision, which we don't have. There is something that, although Masala was an odd case because Masala, the issue in Masala is not failure to investigate or, mental. It's an error that is staring you straight from the face of the record.
Actually, beneath the evidentiary issue in Massaro, there is a failure to investigate concern where counsel did not take the continuance.
When the judge is leaning over saying, defense counsel, would you like a continuance? No, thank you. Defense counsel, would you like a continuance? No, thank you. You can almost see it screaming out at you. But behind that, though, there's considerable merit to saying, let's see if we can get these questions addressed and addressed very quickly, as fast as you can.
Absolutely, and we
don't
have
have
that
that.
mechanism here whereby a defendant would be entitled to only one appeal as a matter of right rather than two appeals as a matter of right, which is the situation that we seem to be in right now.
Oh, wait, hold on. You said no need to adopt Massaro. Our regular jurisprudence takes care of this. So you're conceding that the judge erred in saying that this claim was waived and not ruling on it?
No, actually, I think that the judge's decision can be viewed.
It can be. You can see this judge backing into a substantive review, but that's the difficulty.
Well, the judge at this moment is not in a position to conduct a substantial risk review anyway. We're under Rule 30, and he needs to determine whether a substantial issue has even been raised in order to determine whether to give the defendant an evidentiary hearing. Now, at the time the judge passed on this motion, Hallett was still good law, and I believe that he was concerned about issue resurrection and worded his memorandum to discuss both waiver, and he uses the word substantial as well, which is the Rule 30 language about not raising a substantial issue, and he cites to the Commonwealth's memorandum, which argued the defendant has not raised a substantial issue, and he relies on Commonwealth versus Goudreau, which is a case that's in the procedural posture to this case where the defendant did not raise a substantial issue, and this court did not permit the defendant to proceed. In any event, defendants presently in Massachusetts can file a timely notice of appeal if the facts supporting an ineffectiveness claim are readily discernible from the record. They can proceed on direct appeal on the ineffectiveness claim. If the facts are not readily discernible, they can seek a stay of appellate proceedings.
You're saying the facts, not the issue, the facts.
Correct. If the evidence supporting the
No, not the evidence. If the issue is there, in other words, counsel is very forthright. He said, I saw the issue, but I didn't have the facts, right? You can raise the issue, but aren't you putting that client at risk because you don't have the facts to support it? Yes?
Well, if the facts supporting the claim are discernible from the record. For instance, failure to object to evidence, failure to move for a mistrial, failure to object to a prosecutor's closing. In that event, the issue can be resolved on direct appeal. If not, the defense can seek a stay of appellate proceedings, move in the trial court to adduce additional evidence, and then consolidate the ruling on the motion for new trial with the direct appeal so that the defense...
Think about the practical problems of that. That's delay of years that may delay meritorious legal questions that don't get resolved while this thing goes back for a hearing on some subsidiary matter that may or not develop into an important issue because you don't know yet how ineffective or whether there was ineffectiveness. Isn't that that's a horrible dilemma to put a defendant in?
Well, on the other hand, Your Honor, the situation we're in now is that essentially the defense is trying to ascertain the defendant's mental state at the time of the crimes, which was 9 years earlier than today.
Horrible burden, may not be able to make it. I mean, there's a cost to delaying to the defendant as well. So there is a tremendous cost that they will not be able to reconstruct that in any way that would create any substantial risk.
But in this situation, Your Honor, both trial counsel and appellate counsel were well aware that this issue existed. This is not a situation of newly discovered evidence where waiver principles do not apply. This was well within the record. There was a probation revocation hearing where the defendant's accident and the head trauma that he sustained was at the heart of that. There was a motion in limine from the prosecutor on this issue. And the defendant's injuries and his recovery were the centerpiece of the defendant's sentencing argument. So this was well before trial and appellate counsel.
So you're saying that a motion for a new trial should have been brought and the direct appeal should have been put on hold. And failing to do that, what is the consequence?
Failing to do that, we have two appeals, and we still
a Rule 30 motion after direct appeal.
Correct. The defense.
And that's our law. That can be brought.
That's right. And the doors to the courtroom are never closed in Massachusetts to the defendant for waived claims.
So how should the judge deal with that? That's the point. How should the judge deal with that? The judge say, no, you could have raised it. It's waived. I'm not even going to permit argument on it because it's waived. That's what the judge seems to have done here. Is that a proper way to deal with a Rule 30 motion in this circumstance?
No. Presently in Massachusetts, even waived claims go on to receive review.
Correct.
So the waived claim here, although the judge found that it was waived, the next step should have been a Rule 30 review where he was to determine whether or not the defendant raised a substantial issue in order to give him an evidentiary hearing. That is the interim step before the substantial risk review.
If it could have been raised in a motion for new trial brought in conjunction with the direct appeal, what is the effect of that if it comes later? Is it that the doors to the courthouse, they can still be opened, but they're rusty? They get a little harder to open.
They are rusty. One of the difficult considerations is that the delay often translates into the trial judge not being on the bench anymore. Here he is, but often we currently in Middlesex are dealing with
what that says to me is considerable merit to letting the direct appeal go ahead. I mean, the Committee for Public Counsel Services, and I have no way of knowing whether they're inaccurate, say, just take a look at the history of ineffective assistance of counsel claims on direct appeal. Yes, you can raise them, but and then they identify those cases where it really is clear that the Commonwealth trying to prove somebody guilty provides the sufficient basis for the ineffective assistance of counsel claims, such as insufficiency of the evidence, a claim that was not raised. I mean, you don't need another evidentiary hearing. You know, an incorrect jury instruction, what I would call quintessentially legal on the face of the trial of guilt innocence. Everything else benefits from having a separate record. I mean, that's the Massaro rule. Forget anything else. Having a separate record. The appeal has been confirmed. The appeal has been the conviction has been upheld. the defendant serves his time, we don't have the delays. I'm very troubled at the notion that what we're now going to tell counsel so they don't get into this is what you should do is bring your direct appeal, file a motion, and request a stay, because we just know that gums up the works.
Well, with all due respect, I think these orders can be fashioned such that the defense should proceed at an expedited basis.
It doesn't matter what the defense is doing. We know that it gums up the work if you don't let the appeal proceed as fast as possible. What we're trying to do is to get the appeals through and finished. And if there's a sidelight ineffective assistance of claim because of, some failure to investigate, it's not two appeals. It's just getting the guilt innocence affirmed, the guilty conviction affirmed on appeal.
Well, I respectfully disagree with you, Your Honor, because it gums up the system to have 2 full appeals for every defendant. The trial itself is supposed to be the main event.
Yes, and I'm not sure you're going to get 2 full appeals, but you're going to have a very careful judge saying, okay, the appeal has gone forward, let me just take a look at this. I don't have to worry about waiver. I don't think you've made out a case here. That's essentially what I think the motion judge was saying. That's essentially what the motion judge was saying. Don't have to worry about waiver, what I'm really looking at. I'm just looking at it. You've brought an ineffective assistance of counsel claim. I've taken a look at the trial. I've seen what you've put on. It's gone. And then if the defendant wants to appeal that, fine, let the defendant appeal that.
And that's exactly my point,
But that's not a complete new appeal. What I'm worried about is a suggestion that what this defendant did here, what he should have done was file a motion to stay. I mean, believe me, that is not helpful.
Well, there are no legitimate reasons, no benefit that the defendant has gained by not proceeding in that fashion in this case. In this case, the defendant is serving a lengthy sentence. He is only 9 years into that sentence now.
I'm looking at the people of the Commonwealth wanting to get an appeal, and then if you want to go have a little side fight about whether or not your counsel was effective or ineffective, trial judges can handle that. They do it brilliantly.
I think the key word is one you spoke about 5 minutes ago when you said facts. Before they go for a stay of the appeal, they've got to have facts to support the motion. It's not so much that they might be thinking there's an issue here about ineffective assistance. They've got to have the support for it.
That's right. And here the support...
In that case, if he didn't have the support, apparently it came later as I understand it, it's not waived. And the judge then goes to the analysis of, is this a substantial question I should bother having an evidentiary hearing on or not?
And the starting point to be able to get those facts is with the trial attorney. And it is a glaring omission that there is no affidavit from counsel here.
But again, I'm looking at the overall thing. With some expectation, we're going to make sure that transcripts are prepared on a reasonably timely basis, right? You can assume that is what's happened in the federal courts. So you have 30 days within which to appeal. You get a transcript that should be simultaneously available. We're not quite there yet, but we're going to get there. And so you have a couple of months of briefing, and what counsel is saying is we need time to go out and investigate, and they're not going to have that time while the appeal is proceeding on a reasonably fast basis.
In the particular challenge that Massachusetts defendants, prosecutors, or prosecutors, taxpayers, and courts face in this Commonwealth is that there is no limit on the time in which motions for new trial can be filed. In no other state, in the state courts, is that the case? That they max out at a 3-year time limit. In the other states, they start at 5 days, max out at 3 years, and in the federal court, it's 1 year, and then the motion is time barred. The case is dismissed, not even denied, but dismissed as absolutely time barred.
Well, that's my whole point. We've got a set of very clear rules in place already under a very unique Rule 30 situation. So we don't need Massaro at all. The whole thing strikes me as a red herring.
I agree that we don't need Massaro, but if the court is so inclined, the Commonwealth would request additional relief from the tremendous burdens that the at-any-time provision of Rule 30 places upon the Commonwealth. We currently have a case in Middlesex, a 30-year-old triple murder conviction that is currently in the trial court on ineffective assistance claims. The trial judge is deceased, the prosecutor is
That's my
deceased,
point,
defense
Mr.
counsel
Elias.
is
It may well
deceased.
be that what must happen, and maybe it's not to be resolved in this case, but maybe we should take a look at the overall picture. As I say, Justice Kennedy relied on the fact that it was timely. It was timely.
That's correct.
So you've got a limited time within which to do it, so you don't waive. Thereafter, you've got a massive uphill battle. You've got a massive uphill battle in the federal court.
But if you have a time bar, what do you do if somebody, for whatever reason, just doesn't bring a claim until 5 years later, 10 years later, and there's a substantial risk of misjustice, and you've got some rule that says you had to bring it in 1 year? What do you do?
In the federal court, it appears that defendants are merely time barred and that they do not have access to the court at that point. In Massachusetts, we would continue to have the Safarian standard, but I am seeking the court to rein in those post-conviction motions that can be brought decades after conviction and place tremendous burdens on the court and make an impossible situation for the prosecution. Thank you.
Thank you, Mr. Davis.
All right.